Good afternoon and welcome to this Law for Community Worker webinar, Children's Criminal Court Proceedings, a Guide for Workers. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales, and it's my pleasure to host this webinar this afternoon. We've allowed an hour and a half for today's webinar, so there'll be sufficient time at the end for questions and answers. After the webinar, you will receive a survey, and we do value feedback and we take it into account in our planning. Any suggestions for other topics you'd like us to present webinars on, we try and respond to those requests. So now I'll hand over to the lovely Kylie Anderson-Clark, who will be your presenter for the webinar today. Welcome, Kylie.
Thanks very much, Bridget, and welcome to everyone. I would also like to pay my respects to the traditional owners and the elders of the lands from all of the areas that you are zooming in from, and particularly pay my respects to the Aboriginal workers in this field. I'd also like to acknowledge perhaps the work done particularly by support workers working with young people in out-of-home care and in therapeutic programs. Obviously, it can be very difficult work and sometimes thankless work. When we do come in contact with support workers assisting our clients, like we really value the work that you do, and certainly the assistance that you provide to us as criminal lawyers. The idea of this webinar is to help workers, I suppose, in the care space, working with children who are in out-of-home care particularly, or in more general terms, children who are involved with the criminal justice system, and to try and help workers perhaps understand the processes at various points within the criminal justice system. For many of us, or particularly for many workers, you might not, apart from your work, you might not have had experience in that space, and it can often be an unfamiliar area, and sometimes I think expectations of what actually happens to kids when they go to court can be quite different to the reality. So the idea of the webinar is to try and step through some of the different stages of the criminal justice system where that you're likely to come across in your work. So as you'd all know, like, unfortunately, there are many kids in residential care and in out-of-home care who can quickly become what are sometimes referred to as crossover kids, where they are unfortunately involved with the department because of being placed in care, and because of their particular circumstances in out-of-home care, they can then often come to the attention of police and the courts when were they not in that particular circumstance that might have never occurred. So there are many different issues that that your clients or the children can face, and so whilst as criminal lawyers our client is the child and we're representing them, it's obviously in their best interest for them to be able to be supported by workers who understand the process, and for there to be some collaboration and assistance between their lawyers and their support workers to try and get the best outcome for the child. So the topics that we're going to talk about that will hopefully be helpful is firstly the joint protocol, which aims at trying to keep children who are in out-of-home care out of the criminal justice system. We're going to talk a little bit about why that exists and what it hopes to achieve. Then we're going to talk about options that are available to the police other than charging, so alternatives to coming to court where there is poor behaviour or criminal offending. We're going to touch briefly on apprehended violence orders, what they mean and what that involves for children in the children's court. And we're going to speak a bit about then what happens if there is actually a charge and either the police or the court have to consider whether a child is placed on bail and how they end up coming before the court. And then finally, we're going to try and explain and discuss some potential outcomes in court for the kids that you support. So that if they do come to court for criminal offences, what is likely to be the outcome in the children's court. So perhaps if we can turn to the first topic, which is about the joint protocol and what it is. Perhaps the first thing to talk about is what it, in very general terms, what it aims to do. So the idea of the protocol is to try and reduce police involvement in responding to behaviour by young people living in residential care, and to have the response to that, what can often be poor behaviour, to try and reflect more closely what would happen to a child if instead of being in out-of-home care, they were in fact at home with a family. So the full name of the joint protocol is the Joint Protocol to Reduce the Contact of Young People in Residential Out-of-Home Care with the Criminal Justice System. And there are several aims of that protocol. The first is, as I indicated, to reduce police involvement and having to come where there are behaviours that would be better managed within the service. The second is to promote a principle that criminal charges against a young person don't have to be pursued if there is a different alternative to dealing with those matters. The third is to try and increase the well-being of young people living in out-of-home care by improving relationships between the organisations that are effectively looking after the young people, so between the out-of-home care providers and the police, and to promote the collaboration between those services. And another purpose is to try and have police divert young people away from the criminal justice system and to take into account the background of trauma that is shared by young people in out-of-home care. And finally, to ensure that there are appropriate responses when young people living in out-of-home care are in fact victims of crime. So the idea of the protocol, or what the protocol emphasises, is that there has to be a flexible and proportionate response to a young person's behaviour. Now, there is a document, the document setting out the protocol is available online, and in that document, it refers to, I suppose, the background research and knowledge into why this protocol came about. So many of you, of course, would be aware, just from your practical experience, that children in out-of-home care are much more likely to come to the attention of police because of their behaviour at home than children who live with families. There was some research in relation to that issue, and there is a paper that's entitled "The Drift from Care to Crime," and in that paper, Legal Aid New South Wales identified the trend towards the criminalisation of young people who were in out-of-home care. And just from a practical point of view, as many of you would be aware, there are many children in out-of-home care where the only reasons that they come to the attention of police and to the courts is because of their behaviour in their home environment. So whether that be causing damage to property or making threats or assaulting their workers or other children within their home. Often these children are not children who are offending in a more general sense, where they're stealing or committing break and enters or being involved with stolen cars. Often the only reason why they're coming before the court is because of their poor behaviour, and that is the aim of the joint protocol, to try and keep that type of behaviour away from the court system wherever possible. And the primary focus of the protocol is to acknowledge the trauma that has been experienced by children when they are in, before they reach that stage where they're in out-of-home care, and sometimes while they are in those situations, and to really take a trauma-informed approach to dealing with that poor behaviour. Now, in that document, there is attached to it 2 annexures, and I've only put in the slideshow just the first page of each of those annexures, and I'm hoping that we will be able to eventually share the document with you so that you can refer to it, because it does have some length. But those 2 annexures set out really the procedures or responsibilities of the 2 main parties to the protocol. So the first, which is Annexure A, sets out procedures for the intensive therapeutic services and residential out-of-home care services. And then the second annexure, Annexure B, sets out the procedures and responsibilities of the police. So it's those 2, when we talk about the protocol, the parties to the protocol are the out-of-home care services and the police. And just by way of background as well, whilst the protocol was developed initially in one area of the state, but it is now to be implemented around the state. And I think there's 9 different I suppose centres effectively where the protocol is overseen on a local basis in those 9 different areas. And so, for instance, in our area, there's a particular police officer who kind of has the responsibility of overseeing the protocol, and each of the local out-of-home care services are parties to that, and they all meet and regularly review how that protocol is going. I know that around the state there is a differing implementation of the protocol. The figures in northern New South Wales, where we are, really show a very strong commitment to implementing the protocol, and the number of children going before the court in relation to offences relating to their home environment in out-of-home care really has reduced quite significantly in recent years as a result of that strong implementation, whereas in other areas there is still much more work to be done. So in those annexures, and that you can look at it at your own when you have time to do that, basically there are a number of procedures that are set out in relation to the responsibilities for the out-of-home care services. That focuses on making sure that there are appropriate behaviour support plans and other supports in place to try and obviously address that poor behaviour before it gets to a stage where police have to be involved. And in that annexure, it gives some examples of things that are to be considered by those services, particularly including training for staff, how to identify situations and behaviours, routines within the household, the client mix, and strategies to improve relationships between in the neighbourhood, all matters like that. There is meant to be a liaison officer from each service who is appointed to be able to liaise with the police service. And there is set out in that annexure some guides in relation to what is meant to happen before police are called, and then who it is who has authorisation to call the police in particular circumstances, and then what is to happen after police are called, so a post-incident response. So those things are set out in the annexure, and similarly in the annexure that relates to the police responsibility, it sets out issues that the police are to consider when they are called to respond to an incident. And it effectively sets out that there is meant to be a stepped approach in how they respond to an incident. So it doesn't, the idea is that it's not meant to be that whenever police are called that a child will be arrested and taken away and charged. The idea is that the police are able to utilise all of the tools that they have, so that arrest and putting a child before the court is really to be a measure of last resort. So just some of those steps is that the police can determine after discussing the incident with the workers that there is to be no further action. If there is to be some action taken, the police are able to decide if they can use the tools that are available under the Young Offenders Act, which is, I'm going to talk about that act a little bit more, but it provides a process about how children can be diverted by giving, and in many cases, they can be given a warning by the police. The police can issue an official caution, or in some matters, police can refer a child to what we call a youth justice conference. And all of that can happen without a child having to go to court. So we'll talk about those options a little bit later when we discuss the Young Offenders Act. And finally, in this protocol, it sets out that criminal proceedings are only to be pursued against a child if there isn't an appropriate alternative, if one of those other things that we've discussed is not appropriate. So it's really, I think, important to keep that in mind as workers, in that even in circumstances where your clients, the children, are exhibiting very poor behaviour, that because of their particular circumstances, then there are several alternatives other than police having to charge. The other thing that's set out in the protocol in relation to the police, there is a discussion about when AVOs are appropriate. And often, if there has been violence between two children in an out-of-home care placement, then sometimes police are bound to take out an AVO to protect a child, for instance, who's been assaulted by another. But in relation to workers who are supporting children, if there is violence or threats to a worker, the police don't necessarily have to take out an AVO. That there are that really needs to be something that's considered carefully and only taken out if it really is particularly necessary. So perhaps what we should do is just think about some practical examples in relation to how that protocol might be implemented in real life if there is a situation with one of the children that you are supporting. And that will then lead us into discussing what the Young Offenders Act is as well. So,
sorry to interrupt. I just wanted to double check. There are some questions about the protocol, and I just thought I'd check whether you might want to deal with them now or keep them to the end.
Yeah, well, yes, perhaps we can have a look at those questions now. Yep, certainly.
Okay, so Sophia has asked a question about whether the protocol covers young people returning late home to their placements. She says this often is a factor for police contact and charging a young person for breach of bail. The out-of-home care provider calls police for the young person being late home by 30 minutes, reporting them as a missing person. In turn, police look for the young person and then sometimes charge them if this is part of their bail conditions. It would be great to see some flexibility on this too.
Yeah, well, I think that's an interesting issue, Sophia, because bail, of course, has its own particular issues and constraints. But if there is a curfew bail in place, I suppose it depends on, as part of the protocol, it would be, I suppose, particularly helpful for there to be an approach within the organisation itself that is in terms of the protocol, as far as, is it necessary to report the child as a missing person if your expectation is in fact that they are going to be home soon and that it's just that they are running late. And so that initial issue in relation to whether police need to be involved at that very early stage perhaps needs to go up through the chain of workers first to make sure that it's necessary to call the police. The second issue then is, well, if it is, and if there is particular concern about the child in fact being missing and not just being late, then police do have discretion as to whether or not to breach a child's bail or not, or whether to issue a warning. So I would suggest that if that situation was occurring on a regular basis with the police that you were dealing with, if there was then, I suppose, regular breaching of a child's bail just because they had been late in once or twice in relation to their curfew, that is probably something that needs to be raised at that level with the particular police who are responsible for the protocol, because in all circumstances in relation to children, arrest is to be a last resort, and that includes in relation to breaches of bail. So there are a number of alternatives to the police coming and to arrest a child if they've breached their bail. The first of those is to issue a warning, and so particularly if the workers are supportive of that and are able to explain to the police, look, it's not, we think this is a one-off thing. And then if police are more concerned about the breach of bail, they don't have to arrest the child. They can issue an application to the court, and that can just be served like a normal court attendance, and so that then the child can be given a court date, and then it will be up to the magistrate to look into it. And if there's an explanation given that, well, they have been late, but they've always still been coming home, then the court are not going to revoke that person's bail. So the police do have that discretion, and it's only meant to be as a last resort that they arrest. So I think if they are arresting as a matter of course, that's really something that the liaison officer within the service should be trying to have some discussions to the more senior police about that is an issue that's occurring. I think that.
Thanks, Kylie.
No worries.
There was just one more. Does the protocol cover ACAs?
Sorry, can you just explain what's an ACA?
That was from Sophia again. Perhaps, Sophia, if you could just let us know. But I'll let you get on with your,
okay.
you
All
were
right.
about to give an example.
Yes. So I was going to give an example, for instance, and that would kind of lead us into the use of the Young Offenders Act. And so perhaps just an example would be is if there has been some ongoing poor behaviour and it's come to a point where it's continuing regardless of the steps that the support agency is putting in place, and police are involved. And say, for instance, the poor behaviour might relate to damaging some of their own property, or damaging a relatively small item at home, or to a minor to an assault, such as pushing a worker or pushing another resident in the house, or even perhaps something that's a little bit more serious than that. That is a matter that can be dealt with under the Young Offenders Act, and police can deal with that by perhaps issuing a formal warning to the child. So if there's been very little contact with the police previously and something like that occurs, then often the police will use that discretion to give that child a warning. And so it's important to, I think, for workers to understand the principles that underlie the Young Offenders Act, because I think sometimes as general citizens, like, you might think, oh, this is a terrible thing, or this is criminal offending. And if the child was an adult, of course they would be dealt with very differently. But these discretions that the police have are governed by legislation under an act that's called the Young Offenders Act. And the idea of, or the underlying principles of that act is to ensure that basically the least restrictive sanction available is applied to a child. And the idea of that, of course, is because children have not developed in the same way as adults have. So it's important to kind of always, those principles basically underline all of the legislation that relates to children in the criminal space. Okay, so minor things can be. Sorry, go on.
Sorry. Just to let you know, a few people have let us know that ACAs is alternative care arrangements, so kids in hotels short term. The question was whether the protocol covers those situations.
Look, I think if those short-term arrangements are often I think they can be managed either by the department, by DCJ, or by some out-of-home care providers, such as Casper or MacKillop. And I think the protocol, I think, was specifically designed for children who are in the residential placements, but I think those same principles do apply. And I'm just checking whether DCJ are actually a partner to the protocol. I think they are. Yeah, so the department are in fact the signatory to the protocol. So I think my understanding is that those same guiding principles would apply. And so if there are particular circumstances where issues are arising and the principles are not being followed, either by the department providing that short-term, those motel type of placements, or by the police, then that needs to be raised at that local level with the particular delegates from the department and the police who have responsibility for implementing the protocol.
Thanks very much.
No, and in fact, the principles in relation to charging as a last resort apply to all children, regardless of where they live. But of course, it's the particular issues of children who are in care that are recognised by the protocol. So, in short, yes, it should apply. All right. So, Bridget, are we right to move on to talk more about the Young Offenders Act at this point?
Yes, we are, Kylie.
Okay. All right. So, as I said, in relation to that stepped approach, where it does get to a point where police are involved, then there is a very wide discretion available for children not to be charged, but to instead be diverted under the Young Offenders Act. And the ways that they can be diverted, effectively there's three. And as I said, the police can give warnings. The next step up from that is where police can give official police cautions to children. Now, sometimes for a caution to be deemed appropriate by police, there needs to be an admission by the child of their that there has been offending or that there's been wrongdoing. And the way, and there are some factors that workers can consider in relation to this particular issue. So, for example, if a child is arrested, and it could be for something that happens at the house, or it could be for any other type of reason, and is with police, then police will always give the child an opportunity to obtain some legal advice, and similarly, support workers can also have a conversation with that legal advisor if they think that's helpful. And the way that can happen is that there is a youth justice hotline that police contact, and there is also, if the child is an Aboriginal child, there is also a custody notification line that's run by the Aboriginal Legal Service, and the solicitors will speak to the children and give them some advice. Now, in general terms, when police are investigating a criminal offence, often our advice to clients is not to say anything, not to take part in an interview. Basically, if police have enough evidence, they will charge you, and then your matter can be dealt with at court. So that is often very standard advice that is given to adults. And sometimes it's the initial advice that is given to children, but there is more nuanced advice that is usually provided to children when police speak to them. And that's because of the availability of these alternatives under the Young Offenders Act, where those alternatives are available where there is an admission to the wrongdoing. Okay, so for instance, in a circumstance where there has been some stealing or damaging of property or an assault of a worker or another residence, then in circumstances where that is admitted by the child, then the police can then sometimes deal with that matter by giving them an official police caution, and then that would avoid them having to come to court. Now, often it can be a very stressful and confronting situation where a child is initially being spoken to by the police, and for various reasons, they might not be in a position to be particularly cooperative or to open up or make any admissions when they're first spoken to by the police. And so that's why there is meant to be use of a scheme, and it's called the Protected Admissions Scheme. And under that scheme, the idea is that police will give kids an opportunity basically to go away and consider their position and get some advice. And then if they decide that they do want to make an admission, then they can come back. That admission can be made, and then they can be given a caution. So in one way that scheme is referred to is like a catch and release type scheme, and so the idea is that the kids shouldn't always have to make that decision there and then when they're particularly heightened or in that stressful situation of being at the police station about whether or not they want to make an admission. So if as workers you're aware that that unless there is some pressing reason or it's a particularly serious matter why the police have to deal with it there and then that's something that you can raise with the arresting the police is, well, can we have the opportunity to go away and get some further advice, decide if the child wants to make an admission, and then come back to the police. So again, if that's not something that's happening in your local area, that's something that can be raised at a higher level with police as part of the meetings that they have about the protocol. And what it means by a protected admission is that if police say, well, yes, we're going to deal with you under the Young Offenders Act, and the child agrees to do an interview for that purpose, that admission is protected. It can only be used for the purpose of the police then dealing with the child under the Young Offenders Act. It can't be used for any other reason. It can't be used to say, well, no, we've decided we're not going to deal with you by way of caution. We're going to send you to court and we're going to be able to tell the court everything that you told us. It can't be used in that way because it's protected. So then I suppose the next step up from the police giving a caution is that police can decide that the offence or that the child should attend a youth justice conference. And many of you might have attended one with the children in your care, or you might be aware of this. But again, it's another diversion under the Young Offenders Act. And again, it usually requires there to have been an admission made to the police about the offending. And what it involves is that the police refer the child off to youth justice, and youth justice convene a conference. So there will be a convener from youth justice who runs this conference, which is basically just like a meeting. The child attends with whatever support person that they want to have with them. If there is a victim to the offence, for instance, someone who's had their property stolen or who has been or has had their property damaged, for instance, then they would be invited to attend. And the idea of the conference is that the victim of the offence gets to have their say and to put forward how they feel about what the child did. The child gets to have the opportunity to apologise or to explain their particular circumstances. And the convener helps the parties, and the police also attend, a representative of the police, and the convener helps all the parties come to what we call an outcome plan. And some examples of that might be where the child might write an apology letter, or the child might do some volunteering at a particular service, or there might be some steps taken to have the child enrolled in a particular course or education program. So there's some examples of what might happen at a conference. And so those conferences, if a child is properly supported, bearing in mind their particular vulnerabilities, they can be really valuable as far as helping the child to understand the consequences of their offending. So the police, as I say, have that discretion where they can divert the children in those three ways before, and there really needs to be an exhausting of those options before there is a resort to having a child come to court for their offence. Okay, so I think that was what I was going to say about the Young Offenders Act. And when we talk more about potential court outcomes, I'll just remind everyone as well is that those diversions under the Young Offenders Act, they're also available to a magistrate if a child does end up before the court. And there are only certain offences that don't come under this scheme. So most offences, even if they're quite serious, potentially can be dealt with under the Young Offenders Act. There are some particular ones, we won't go through all of those ones are, but perhaps the ones to bear in mind in relation to some of the types of offending that occurs in out-of-home care are that charges of intimidation and charges of breaching apprehended violence orders can't be diverted under these schemes. So it doesn't mean that all domestic violence offences can't be diverted, because assaults and damage and other serious offences can be, but those particular offences of breaching apprehended violence orders and intimidation, they can't be dealt with under the scheme. Okay, so I think the next topic that I wanted to turn to was in relation to apprehended violence orders. And as workers in this field, you've probably have some experience with these orders, and you are aware that they are tools that police can use to try and, I suppose, curb particular behaviours. But the way that they are, the outcomes in relation to apprehended violence orders in the children's court can be quite different to how they are with adults. When the police take out an apprehended violence order against an adult, then if the order is made by the court, there is normally a final order that's made usually for about 2 years. They can be made indefinitely, or there can be 5-year orders, but normally there is a final order made for about 2 years. Now, having an apprehended violence order made against you is not, of course, a criminal offence. It's a civil application, but they can be used they can have particular consequences. Firstly, if someone breaches them, but they can also have other civil consequences as well. So, for instance, an adult who had an AVO where the person to be protected was a child, then that can be something that's considered if they apply for a working with children's check. So, I suppose the seriousness of an apprehended violence order and its consequences is really why in the children's court there are different processes for what happens to apprehended violence orders. So when you're in the when they're in the kids' court, there's what we call, there's a children's court practice in relation to AVOs. So it's not within the legislation, but it is a practice or protocol that the children's court follows. And so usually what it means is that a child doesn't have to admit that they've done anything wrong, but there can be consent given to there being a short temporary apprehended violence order made. And if at the end of that time there hasn't been any breach of the AVO, then the court will dismiss the application. So there's not usually a final order ever made against a child. Normally there is a temporary order. So and the time of that temporary order depends on the circumstances of the child, but it can be made for a shorter period of 3 months if the court is informed that that child is undergoing appropriate counselling, or if there's not suitable counselling in place, it can be in place. It's usually in place for about 5 months. And then if there are no breaches of the order, then the applications are dismissed. Now, just in relation to that issue about a child being involved in appropriate counselling, often children in out-of-home care are seeing your particular behaviouralist or trauma-informed therapist. So if that is happening and there's an AVO that's taken out, it's important to let the child solicitor know that, so that the order can perhaps be a 3-month order rather than a 5-month temporary order. And some of the places that if there's not counselling being given within your service, then of course there's Headspace and there's Life on Track and organisations like that that offer appropriate counselling that you could line up for the child. What is important to note is that a breach of an AVO is considered a serious criminal offence, and so that if you're the maximum penalty that is available for an adult who breaches an apprehended violence order is 2 years imprisonment. So it is considered to be a serious offence, particularly if the breach involves violence. Again, that's something to bear in mind in considering whether or not it's appropriate for there to be AVOs in place protecting workers who are working on a regular basis with a child, so that, of course, sometimes they could be a really useful tool, and if the organisation thinks that a child is going to respond to them, then they could be a particularly appropriate and useful tool. But in other cases, they can lead to difficult and serious consequences for the child. Okay, so I think, and I think the reason for raising an AVO at this particular point is that again, they can be an alternative to charging that the police can use. So sometimes there's not a need for charging if there is an AVO, and that can be perhaps if there is an offence involving one of the children in the house against another child, then sometimes an AVO will be enough. In relation to AVOs themselves, if they involve, it doesn't place an obligation on both parties. So the obligations are only on the defendant child. So it doesn't do anything. Sorry, the person who's to be protected by the AVO, they don't have any obligations. So for instance, if there is a condition that there is to be no contact, then the person who's to be protected, there's no sanction for them if they keep contacting the child. But of course, there is for the defendant child. They're the ones who have to stick to their conditions, regardless of what the person who's to be protected wants. So I suppose that's more common within a relationship situation where there might be an AVO made where a child is not to have any contact with their former girlfriend or boyfriend, and their former partner, they might say, well, I don't want the AVO, like you can come around here, that's fine. That's not the case, of course, and there are serious consequences for breach, particularly in relation to them being charged with breaching that AVO. So I suppose as workers, it's important to be aware of the conditions of the order and to make sure that the child is able to properly comply with them. I think on the next slide, Bridget, we've just set out the standard conditions of an apprehended violence order. And so the standard condition is condition 1, which relates to basically just preventing criminal behaviour towards another person. And then there are a number of additional conditions that can often be problematic for children. So you really have to be vigilant in relation to seeing whether or not any additional conditions are appropriate. And so those type of conditions normally involve not having contact, not approaching if they've been using drugs or alcohol, not going to a particular address, conditions like that. And if a situation changes, for instance, if you're aware that one of the young people in care is now back in a relationship and there's still a no contact AVO in place, then an application can be made to the court to vary an AVO. It might not always be granted, but there's scope to make such an application. Right. All right. So I think the next thing that I was going to talk to is to talk about what happens if the matter is actually one that is serious enough, or police deem that it's appropriate that proceedings do commence against a young person and that they have to attend court. The first thing to bear in mind is that a child being arrested, so taken into custody and then placed on bail, that is meant to be a sanction of last resort. So court proceedings can be commenced just by police serving the young person with a notice to attend court. And that's obviously always a more desirable situation than being arrested, taken away to the police station and then released on bail. And even if an arrest happens, if there is a difficult situation and police do arrest a young person, they can effectively unarrest them and then give them a notice to attend court. There doesn't always have to be bail. Bail is only to be put in place if there are particular bail concerns. And so when police and the courts decide that there is a need for bail, that is governed by the Bail Act. That applies to adults and to children. And in short, the court has to consider, or the police have to consider, is the young person going to turn up at court? Is there a risk of further serious offending? Is the victim going to be adequately protected? They're the main concerns that both the police and the courts have to consider when deciding if they will grant bail. So often, if there is repeat violent offending in relation to, for instance, workers within an out-of-home care situation, then police will often refuse bail if there is further offending. If a child's already on bail, they keep offending in a violent way, then police will often refuse bail, and then they will have to come to court and have that bail determined by the magistrate. So I suppose as workers, if you're supporting a young person who is at the police station and police are considering whether or not to grant bail, if there are particular supports that you can tell them about that are put in place, or if, for instance, there's going to be a different placement, or whether those particular workers are not going to be still working with the young person, or if the violence or conflict relates to two children within the same placement, if the other child is going to be living elsewhere, it's really important that you would stress those things to the police, because that might sway their decision in relation to whether or not to grant bail. And so the things to bear in mind are those particular bail concerns. Can those risks be addressed appropriately by the police granting bail? Can they, and particularly what they're usually concerned about is the child at risk of continuous serious offending, and is the victim of the offences going to be protected? Now, let's say, for instance, it gets beyond that point and police refuse bail and the child then has to go to court. What happens then is that the magistrate, the children's court magistrate, then has to decide or look at those same issues. Can there be a grant of bail? So can those bail concerns be addressed by bail conditions? And in practical terms, at this particular point where a child is bail refused by the police, that's when there is often involvement of an arm of DCJ called Youth Justice, and there are youth justice workers who will speak to the young people and speak to their carers or support workers about what is available for them. If they were to be granted bail by the court, where would they be living? What would be done to try and address their behaviour? And they normally prepare a short written report for the court. So if there is anything helpful that you can do as support workers at that particular point in liaising with the youth justice bail worker, then that's obviously very helpful. Again, the court considers that report, the court considers the offending and those risks that I've talked about, and then they decide if they're going to grant bail. And again, because of the underlying principles set out in legislation to do with children, then the least restrictive sanction is to be put in place. So wherever they can address those bail concerns, the court will grant bail, and it's only where they can't, those bail concerns can't be addressed, that a child should be refused bail and held on remand. So let's assume that they are granted bail. then there are usually some conditions in place. And for some children, that condition will just be to turn up at court on a certain date. For other children, where there is offending late at night, or if they're committing break and enters away from the house, and that's at night time, if they're riding in stolen cars at night time, the court might consider additional conditions such as a curfew, or such as non-association, so not being around particular other children or friends who are involved in the offending. But what conditions are put in place, again, that's governed by the legislation. And what the Bail Act says is that the courts only, and police as well, this applies to, but they're only to impose a bail condition if that's necessary to address a bail concern. So sometimes that's an issue that workers or organisations raise with us as lawyers for the children, is that, well, can they be on a curfew, or can this curfew continue because we're finding that very helpful as far as keeping the child at home and having them come home. But if the offending is happening in the house and is directed to workers or to property, or it's happening in the daytime, then the court is not going to think that a curfew is appropriate. So, and depending on the magistrate's views, a magistrate might say, well, like, those bail conditions, they're not a behavioural tool, or they're not a punishment. They're only meant to address those particular bail concerns. So I know sometimes workers can feel frustrated by the courts or by the child's lawyers when those curfews are removed, because of course none of the kids want those curfews. But you really need to bear that in mind, is that the conditions are aimed only at addressing bail concerns. I think on another slide I've put that there is processes that are available to vary children's bail conditions. So I wonder if we can turn to those, Bridget. That next slide is that. So bail is something that is monitored carefully by the police normally for kids who are in out-of-home care. So if there is a need to change bail conditions, for instance, if there is to be a new placement, or if there's some reason why a child needs to be out after hours, or they need to associate with another child who's within the same service, it's really important to try and have that bail varied as soon as possible. So some conditions can only be varied by the court, and I think there's just a form up there that is just an example of the forms that are used. And so the solicitor for the child can put in that application, or a worker can put that application in at the courthouse, and then that will be listed in court. And then on the next slide, there is just an example of, there's a different type of application where if it's a simple thing, then bail conditions can be changed just by a justice, who's like one of the registrars in the court office. So if there's just a change of address to a different placement, or if there is a need to change a reporting station or something like that, then those conditions can be changed basically in the court office if the police agree. So again, either you can ask the solicitor to do that form for you, or that's something that you could do as a worker just at the court office, and that some changes don't have to go back to court. They can be done. They can be done just in the court office. And I think from the question, I think that was asked by Sophia earlier in relation to breaches of bail, it's very important, obviously, to keep on top of bail and to know those conditions, because if police become aware of serious breaches of bail, of course, the charge, what happens is, it's not a criminal offence to breach your bail, but what it means is the bail that you were on can be cancelled by the court, and then the child remains in custody till their charge is finalised by the court. So I think the next topic that we were going to go on to was basically just what can happen when the matter is before the court. And I touched on briefly before just the issue of expectations, in that I think sometimes where you're not familiar with children's court criminal proceedings, you might have very different expectations of what might happen. And sometimes that's reflected in the media, where the media, there's an outcry because children who have been stealing cars or breaking in have been released by the court or given what they describe as being a slap on the wrist. And so it's important to have appropriate expectations about what happens in the children's court, and to understand that children are dealt with very differently to adults, and that principle of dealing with them in a different way is entrenched in the legislation to so that it's not that a magistrate is particularly lenient or not taking into account community concerns. Is that one of the overriding principles, of course, is that children are to be dealt with as children. They're not at a stage where they have developed an adult mentality, and so that they're dealt with accordingly. So when a child comes to court, of course, they will decide whether they're pleading guilty or not guilty to their charges, and every child is entitled to legal aid regardless of their means or circumstances. So it would be usual that a child would be represented either by a legal aid lawyer or a lawyer from the Aboriginal Legal Service. So after they receive that advice, they'll either plead guilty or not guilty to their charge. And so if someone pleads not guilty, their case will go to a hearing. The court will hear evidence and then determine the outcome. What we're more focused on today is just in relation to what would be the usual range of outcomes that if they are either found guilty or they decide to plead guilty to their charge. And so they're listed out on the slide. And as I indicated before, the court has the same powers under the Young Offenders Act as police do, in that most charges, they have the capacity to either issue a caution to the child, a caution or a warning, or to send them off to a youth justice conference. And then under different legislation, so under the Children's Criminal Proceedings Act, there are a range of stepped penalties that are available. And of course, they depend on whether the child is a first offender or has had numerous appearances before the court. So I suppose in range of seriousness under that legislation, again, a court can decide simply to dismiss a matter with or without issuing a caution. The next penalty up is a fine, and that's not usually given in the children's court because most children don't have the means to pay a fine, but it is an available penalty. The court can place a child on a good behaviour bond, which is effectively a promise to the court to be of good behaviour for a certain period of time. And then there are more serious community-based orders. So a step up from a good behaviour bond is a probation order. A step up from that is a community service order, where they can be effectively made to do unpaid community work. And then the most serious penalties that are available are called control orders. And a control order basically just means a jail sentence for a young person. So not being served in an adult jail, but served in a juvenile justice centre. In this area, there's Acmina. In Sydney, of course, there is Reby and a number of other different centres. And there's also available a suspended control order. And so what that means is if a matter is particularly serious and the court thinks that it needs to impose a period of control, then they can impose an order, say, for instance, a 6-month control order, but that can be suspended. So it means that if a child is of good behaviour for the next 6 months, they don't serve that 6 months. But if they're not of good behaviour and they commit more offences, they can be brought back to court, and then the court can impose that 6 months, or can send them into custody for that 6 months. So in each of those penalties that are available, like ranging from the good behaviour bonds up to control orders, those orders can be made to incorporate the supervision of youth justice. And as I said before, youth justice are another arm of DCJ. So they have particular workers. Often the workers will come to court, but if the court orders a child to be on the supervision of youth justice, then they will meet with them regularly, and they'll try and divert them into some appropriate services and support, with the idea being to try and stop them reoffending. So I think then the final topic that we were going to talk about is just an alternative to sentencing. And often it's very relevant to children who are in out-of-home care because of their history of trauma, is that sometimes children can be diverted under the mental health legislation. So that act is called the Mental Health and Cognitive Impairment legislation. And what it means is that if a child is suffering from either a mental health impairment or a cognitive impairment, then the court can decide if, rather than dealing with them in the usual way, if it's more appropriate to dismiss the charges under the mental health legislation, then they can do that, and then they can release the child, instead of receiving a sentence, for instance, the court can discharge them with appropriate treatment in place. And you might, as I said, it's something that often is applicable to children in out-of-home care, and it's very frequently, it's very common that, for instance, a child might suffer from ADHD, might have a diagnosis of ODD, as well as a particularly traumatic background and a diagnosis of PTSD. So, for instance, in those circumstances, even when there are serious offences, the court will often divert under the mental health legislation. And just to give you an example, we recently had a young girl who was dealt with by the court under this legislation, and you might have heard of Section 14 orders. That's what it means. And she had, I think, approximately 20 charges involving quite serious damage and assaults on workers within her placement. The court considered the material about her background and her particular conditions and dismissed her charges on the basis that she continue to engage in various treatments that were put forward in her support plan. So an example in her particular case was that she continued to see her paediatrician, she take medication as prescribed, she engaged with the Child and Adolescent Mental Health Service, which she was already linked in with, and that she see a counsellor as arranged by her provider or by Child and Adolescent Mental Health Service. So it's really important that if you're aware of a child having those particular diagnoses or trauma history, that if you do have available to you reports or information about that, that can be provided to the child solicitor, because it can really help in achieving a much better outcome. And again, the idea of that diversion is to prevent offending by addressing the underlying behaviour. So they're the areas that I thought are the main areas that you'll come across within the criminal justice system. I know that's a very brief overview of a complex system. On the last slide, we've just put some where you would get help from in relation to contacting legal aid or the Aboriginal Legal Service. And of course, sometimes if you want particular advice about a particular situation, and particularly whether or not a child should do an interview, that type of thing, then you can contact whatever is the local officers in your area. So I think, Bridget, if they're the issues that I wanted to cover.
Thanks so much, Kylie. We've got some questions that have come in during the presentation. So I'll just run through those now. We've got a question, is a transition order the same as a recovery order?
Look, I think that is not necessarily a criminal issue. And I'm a criminal solicitor. I'm not a care solicitor. So I can't tell you the answer to that question. I think that would be an issue for to be raised with a family lawyer.
We might be able to put that question to a family lawyer,
yes,
and respond by email to that question. Cherie has raised that she'd like to ask about the legalities of conducting searches of young people's rooms in alternative care arrangements. And she said the question is in relation to young people in out-of-home care and young people on bail.
So, and I'm assuming whether you mean that that's by police rather than by workers. And if that's what you mean, if there is to be a search by police, then that can only happen in particular circumstances. Normally, for there to be a search of somebody's home, then there would need to be a search warrant. There can be a search done in circumstances where police suspect that a crime has just occurred, or there is an offender who is like hiding in that area, and they suspect they have just committed an offence, or there is an outstanding warrant, then they're able to make that search. And in relation to personal searches of young people, wherever that might be, then that can only happen if police have a reasonable suspicion that they either have drugs or weapons or stolen goods upon them at that particular time. So I'm not sure if that exactly answers your question, but if there were other kind of particular instances, then I'm happy to reply later by email.
Thanks, Kylie. The next question is there a process to appeal an AVO for young people?
Yes, there is a process. So there can be an application made to revoke or vary an AVO, and that can be made just to the same court, to the Children's Court, or if the Children's Court is not in a position to vary or revoke an AVO, there can be an appeal to the District Court. And so an application to revoke or vary to the Children's Court can be made at any time while the order is in place. And that appeal to the District Court, that has to be made within 28 days of the decision being made, or within 3 months with leave. So you just have to bear in mind those, beg your pardon, that there are those time limits. So that's probably something that if there is an issue, it should be discussed with their representative as soon as possible.
The next question is, what is done to support young people who don't have a cognitive impairment or mental health diagnosis yet?
Right. Well, it can, often if there's not yet a diagnosis, but it is suspected, and then sometimes assessments and reports can be obtained by through legal aid or through the Aboriginal Legal Service. And if you're saying, if the question relates to that information being important for their court case, then sometimes if it's suspected, and often it is suspected or very obvious to adults who are supporting young people that there is something that's not right, then sometimes those reports can be funded by legal aid or the Aboriginal Legal Service, or their cases can be adjourned for that information to be obtained if it's necessary. If you think it's appropriate that it's needed, that the court should know about that information.
Thank you, Kylie. Cherie's has clarified that the question about searching young people's rooms is searching by workers.
By workers, yeah, that's a bit, it is a fraught area because there are, it's a little bit, if I suppose, if you can compare, well, if a child is at home, what can a parent do? And of course, there's no prohibition on a parent searching a child's room or looking through their room if they are worried about them having drugs or weapons or stolen goods within the home. And I think that's something that would more be a matter of policy within each particular organisation. But certainly it would not, workers would not have the right to conduct physical searches of the child themselves. In my opinion, that could be considered an assault in some circumstances, unless it was an emergency type situation to try and disarm a child or something of that nature. But I think the House rules would have to be very clear, and of course workers would have to, if workers had concerns about those things potentially not being lawful, that would need to be discussed with the managers as far as how that would occur. But it's where the organisation is effectively acting as a parent, then a child wouldn't necessarily have the right to say, well, no, you can't come in my room or look at my stuff.
Thanks, Kylie. A couple of questions sort of asking for your view about situations. So is there a benefit to raising the age of culpability to 14 years?
Well, in my opinion, yes, very much. It's a really difficult situation for children who are aged between 10 and 13 coming to court. That's that issue in relation to criminal responsibility and the issue of dolly incapax I haven't touched on in this presentation, but you would find as a worker, no doubt, if there was an 11-year-old, 12-year-old, 13-year-old charged with offences and going to court, then it would often be the case that their solicitors would be discussing that issue and pleading not guilty to offences where the behaviour has occurred, but where really the only issue is whether or not the child is criminally responsible because of their age. So that is something that is often important in the children's court, but really is a whole nother issue. All of the studies, of course, point to children's level of understanding and appreciation of serious consequences not being developed between the ages of 10 and 14, and even, and of course, as from our practical experience, even when children are much older and they're 15, 16, it's still obvious that they're acting not as adults in their understanding. So yes, in my opinion, there could be a lot of work done to divert many more children, and it would prevent the consequences of ongoing involvement with the criminal justice system if children between the ages of 10 and 13 could not be charged.
Thanks, Kylie. There's another question. What type of support system is placed for young offenders? I think is in place for young offenders, which will help them avoid becoming serious offenders in their adult life?
Well, in each of those, I suppose, ways in which children can be dealt with, well, perhaps firstly, the most important thing is that is for organisations who are supporting young people in these difficult circumstances, is that there is no need to wait or an expectation that the court or the police are going to be able to appropriately address those issues, and so that any supports that can be put in place by organisations such as behavioural therapists and education, counselling and mental health diagnosis and support, those are the most important things. But when a child does become involved in the system, in each of those steps along the way, there is meant to be an opportunity to address those issues. Youth justice conferences particularly are meant to try and have that restorative justice component to help a child understand consequences and for there to be an outcome plan. The involvement in youth justice in any of those supervised orders, their whole the way in which they operate, everything is designed to try and stop children coming back to court and be ongoing offenders. And similarly, mental health diversions are meant to have that same effect. But in my opinion, things that happen outside court are far more effective than anything that happens within the criminal justice system. So anything as workers that you can do to support the young person outside of the court is going to perhaps contribute much more significantly to that reduction of reoffending.
Thanks, Kylie. The next question is whether you think the youth justice system is moving towards a therapeutic jurisprudence model and what would need to happen at the Children's Court to achieve this?
I think that is very perhaps dependent on, at the moment, is a little bit arbitrary in relation to where you're dealt with. The Children's Court can operate in different ways, in that there are specialised Children's Court magistrates who deal with criminal matters. And I think where that occurs, there is a more therapeutic and trauma-informed response that is taken. Local court magistrates in areas where there are not specialised magistrates operate as the Children's Court magistrates as well. And I think in those circumstances, sometimes it's hard for them to change their hat effectively and use that same approach. But I think there is perhaps there is more work that needs to be done in that early diversion and early intervention by the Children's Court, and perhaps a much earlier involvement of support services such as Headspace and counsellors, in my opinion, because I think once it gets to a stage where youth justice become involved, then often there's a lot of water under the bridge by that time. And so it would be, I think the Children's Court would be more therapeutic if there could be earlier interventions.
Just got one last question. We're slightly over time, but only by a minute or two. Just whether Dolly Incapax should apply to diversions under the Young Offenders Act.
Look, yes, I think it should, but it doesn't have to. So it's not something where police have to make a determination, as a magistrate would, whether Dolly Incapax has been rebutted, so that the police don't have to make a determination about whether or not they think a child has the capacity to understand serious consequences. So it is quite frequent for children who are 12, for instance, 12 and 13, to be receiving cautions or conferences or warnings. So it doesn't apply. But I think if as a support worker you have particular concerns about a child's ability to understand consequences, and particularly if they suffer from an intellectual disability, then that's something that you might need to be, or it might be appropriate to raise with the police, because it might make a difference about whether they consider that they, in relation to what step they take, if they're aware of those particular issues. Bridget, I've just lost sound. I'm sorry, I can't hear you.
Oh, I'm sorry.
Yeah.
Thank you. Thanks for letting me know. I just wanted to thank you for a really interesting and thorough presentation about the involvement of children in criminal proceedings, and to thank everyone for their attendance today, and to let them know that I will send a copy of the presentation by email. I had trouble uploading it into Zoom during the presentation today. And if you have any further questions, you can direct them to celia@legalaid.nsw.gov.au, and you'll get some links, and we can send a link to the joint protocol as well after the webinar today, as well as a link to the recording, because this webinar has been recorded. So thanks again, Kylie, and everyone for attending, and we'll close off the webinar now.
Thanks, everyone.